The court addressed two questions. First, it asked, does Congress have the power to incorporate a bank? And then it addressed the second question of whether Maryland could tax the bank. The opinion was written by the Chief Justice, John Marshall, for a unanimous Supreme Court. Now, Marshall was interested in upholding doctrines of national sovereignty and broad construction of the Constitution and of the supremacy of the federal government. What was Marshall's response to the question of whether Congress had the power to incorporate a bank? Well, he made a number of points. Let's focus on the main ones. First, he said that political practice suggested that the power was constitutional. He pointed out that the first Congress enacted a bank bill and that it was reenacted later. Thus, he concluded this can scarcely be considered an open question. However, he went on to consider the claim that the power wasn't listed in the Constitution. And he responded by saying that the Constitution can't cover everything. As he put it, only its great outlines should be marked. In famous language, Marshall wrote, "We must never forget that it is a constitution we are expounding, as opposed to a legal code which wrote everything down." He continued on this theme. The Constitution, he wrote, is intended to endure for ages to come and consequently to be adapted to the various crises of human affairs. This meant that the Congress must have flexibility in implementing powers. Otherwise, Marshall warned, the Constitution would be what he called a splendid bauble, a showy trinket, a mere toy. He then argued that power requires the means to exercise it. A government entrusted with what he called such ample powers as the Congress is given in the Constitution must also be entrusted with ample means for their execution. Why, Marshall asked, give Congress broad powers and then impede the exercise of them? And then he adopted the Hamiltonian argument. He said the power of creating a corporation is never an end, but only a means of accomplishing other powers, and therefore it need not be expressly mentioned in the text of the Constitution. He turned then to the necessary and proper clause, and he interpreted necessary to mean only convenient or useful, and not a limitation on congressional power. Then he concluded, and let me read his conclusion. Marshall wrote, "Let the end be legitimate. Let it be within the scope of the Constitution, and all means which are appropriate, which are plainly adapted to that end, which are not prohibited but consist with the letter and the spirit of the Constitution, are constitutional." The court then turned to the second question, can Maryland tax the bank? And it said no. The power to tax, John Marshall wrote, involves the power to destroy. And he interestingly pointed out that when a state taxes its constituents, it taxes people who can respond. If Maryland has a tax in Maryland, the people don't like it, they can vote the legislators out of office. But that's not the case when a state taxes the federal government. Here, the people of the United States could not throw the legislators of Maryland out of office. If this was right then, if the states could tax the federal government, they could effectively curtail its operations. Marshall said they could tax the mail, they could tax the courts, and etc. It would change, as he put it, totally the character of the Constitution. The American people, he concluded, did not design to make their government dependent on the states. Marshall's conclusion, therefore, was that the states had no power to control the operations of constitutional laws of Congress to carry out constitutional provisions. What do we make of this decision? Well, there were a number of criticisms, as you might imagine. Some have argued that the opinion is a broad and dangerous assertion of congressional power. What limits the Congress under this holding? Is the means test end too broad? Others have suggested that it's a broad and dangerous assertion of court power. Does this mean the Supreme Court can respond to any crisis? Marshall's famous line, "We must never forget that it is a Constitution we are expounding," sounds lovely, but so what? The question is, how is it to be interpreted? And critics allege this decision gives the court much too much power. Now, politically, there was opposition from states' writers. Consider some editorial commentary. A Philadelphia paper wrote this. The decision, it said was a most lamentable sophistry, the most flimsy and false attempt at reasoning in the annals of any nation, a monstrous tissue of weakness. An Ohio paper said the court saddled a monster of iniquity upon us. And the popular Weekly Register wrote, "Every person must see in the court's decision a total prostration of the states' rights and the loss of the liberties of the nation." In terms of political action, after the case, the state of Ohio, under its own law, seized by force $100,000 from the branch of the U.S. Bank in Ohio. And that led to another Supreme Court case, Osborne versus Bank of U.S., where McCulloch was reaffirmed. And despite McCulloch, President Jackson vetoed a recharter of the bank in 1832 on the express ground that the bank was unconstitutional. Let me read you part of what he said. President Jackson said that constitutional questions could not be regarded as settled merely because the Supreme Court had issued a decision on it. He wrote in part, "The Congress, the executive, and the court must each for itself be guided by its own opinion of the Constitution. The opinion of the judges has no more authority over Congress than the opinion of the Congress has over the judges. And on that point, the President is independent of both." But McCulloch is generally considered a great decision. It was aimed at upholding doctrines of national sovereignty and broad construction of the Constitution. It was based on the structure and the relationship between the states and the federal government, and it supported national power and congressional action. Indeed, many commentators consider it a brilliant decision. Maryland was right. There was no enumerated power to charter a bank in the text of the Constitution, but a national economic system could hardly have been created without such congressional power, and the Supreme Court's role was to uphold a broad reading of that power. Although nearly 200 years old, McCulloch versus Maryland remains at or near the top of every list of the Court's greatest decisions.